Good afternoon, everyone, and welcome to the Helen Swisman Foundation's third of three webinars in our South Africa and the World series. And what we're trying to do with these webinars is to get panels of experts together to discuss South Africa's role in a global world. South Africa is often not only at the mercy of global trends, but also can be an actor in global trends, and that those are sort of two dynamics to being in a global being a part of a global pattern of activities that we're trying to explore with these webinars. And today, I think we probably have one of the most poignant topics in this theme: the idea of regulating digital spaces, which are increasingly global and seemingly out of control of domestic jurisdictions. So we hope that you enjoy what we have to say today, and thank you so much to our panel for joining us. I'm going to hand over now to Thandi Smith, who's the head of programs at Media Monitoring Africa, and she's going to moderate our discussion today. Thank you, Thandi.
Hi, good afternoon, everyone, and thanks again for joining us for this really important discussion. I think the topic of digital harms and disinformation has been one that has really been at the forefront over the course of the year, especially given the elections year that we've had, and it seems to be an area that is getting a lot more interrogation and discussion and debate. So I'm really looking forward to quite a engaging session. As you know, we've got a fantastic panel who will be giving us some opening remarks, some thoughts, and a short presentation. We'll just be talking through the topic. There are no formal presentations, and then there'll also be opportunity for you to engage with the speakers. So please, throughout the session, if you have any questions or comments, please post them, and I will pose them to the panel. By way of introduction, we are joined today by Kavisha Pillay. We also joined by Tina Power and Sherylle Das. And I have to say that it's always fantastic to be part of an all-women panel. I think it's great to just highlight that. So thank you. I'm going to further introduce the speakers. Kavisha is a social justice activist and former head of stakeholder relations and campaigns at Corruption Watch, and she is a founding director of the Campaign on Digital Ethics. Tina Power is an attorney of the High Court of South Africa and an associate director at Power and Associates. Tina works closely with civil society organizations working on digital rights and responses to online violence and digital attacks against women. She has engaged in domestic, regional, and international law reform and advocacy initiatives aimed at enabling a healthy information ecosystem and promoting accountable platform governance. Sherylle is the regional director of the Legal Resources Center. She heads the Democratizing Big Tech program and drives the agile strategy of the LRC. Sherylle's previous roles include managing attorney of Harris Nupin Molebatsi Incorporated, where she practiced philanthropy law, servicing various nonprofit organizations. Prior to this, Sherylle was a senior attorney at the Equal Education Law Center, and from 2007 to 2013, she managed the Refugee and Migrant Rights Program in Durban at Lawyers for Human Rights. So we really have an expert panel to talk to us about these issues. We're going to be setting the scene around challenges of mis and disinformation, the challenges that it poses to democracy, mechanisms at which disinformation is distributed, how algorithms work, how it creates these echo chambers. So we're really going to get a practical sense of the challenge that we're dealing with. We're then going to move on to some sort of a focus on regulatory and legal mechanisms and how we're seeing these challenges play out and what it means for South Africa. So I'm going to hand over to Kavisha, who will kick us off in the discussion by setting the scene. So Kavisha, over to you.
Wonderful. Thanks so much, Thandi, and thanks for doing this, HSF. I think this is such an important webinar to have, and an important, we have to be on this journey of trying to see how we can hold big tech accountable. So I want to start off with just a bit of a personal anecdote about disinformation. Sometimes when we think and talk about disinformation, we tend to refer to people that are outside of our networks and circles because, it may feel unlikely that your loved ones may be disinformed to a point where they are believing conspiracy theories and others. And I know I'm not alone in this, but I thought just to break some ice, share a bit of a story with of family members that are really close to me who, through consuming information on YouTube and what started off as just watching yoga videos and meditation videos, they were pulled into a rabbit hole of Hindu right-wing nationalism. Now, for background, we grew up in a multicultural community in Indonesia, and that these family members of mine were pretty progressive, and we're, come from a Hindu family. But that was never a reason for discriminating towards other people. But as Modi in India, and a lot of his rise in India and his appeal, his populism, was through using quite violent rhetoric and othering in terms of his disinformation campaigns. That was also then streaming into more localized areas. And these family members of mine who I'm very close to and love quite a lot, it becomes difficult when we start having these conversations because no matter what you put on the table in relation to Modi and how dangerous he is, they can't see beyond personal biases and blind spots. And for me, it was one of the main motivations for why I started Code, was we're putting powerful devices in the hands of people. Unknowingly, they're consuming content, and that content may take you into a rabbit hole, which can lock you in there and play into your fears and your perceptions. And that then starts to potentially alter your worldview, how you engage within communities, and how you start to view other people who don't conform to your religious beliefs or cultural beliefs and so on. And I know that this story is so familiar, whether it's about religious beliefs or beliefs around vaccines and COVID and so on. What we're starting to see is a lot of polarization and people being locked into echo chambers. So false information in that regard is not new. It's been around for a very long time, and it has been weaponized by politicians and others, corporates and so on, in order to influence people to not behave or vote, and not vote in different ways. I think that the difference about where we're at right now is that the algorithms on social media are able to target you based on your location, based on your likes, based on your interests, with information that can influence you in particular ways. And then you're also, once you start engaging with that information, if you are unaware, you can then get locked into echo chambers. And again, this is becoming quite prominent in our spaces where somehow we've just don't seem to dialogue with each other anymore. So you're either on either side. And I think we're starting to see those types of cracks emerge in democracies all around the world, where you see a complete fragmentation of people who are voting right and left. And what the long-term implications for that, I think, can be quite disastrous for democracy. But in that understanding, and with the introduction of technology, we've also seen an evolution of the information landscape. So according to a Reuters report here in South Africa, most South Africans consume their news online. And what we're seeing is that there's also a shift in the types of information that you're consuming. So traditionally, you may, be reading media reports, news articles, engaging with journalists and political commentators. But in this era of influencers, we're starting to consume information in different formats. So not just, bulletin reports and news reports, we're consuming podcasts and 30-second TikToks and so on. And that is now starting to alter how we are engaging in the space, because on the one hand, that the way in which we're consuming information may lock us into our own echo chambers, because we do have the luxury to pick and choose the type of information that we want to receive. So if I feel that this particular reporter or media outlet has a political ideology that I don't agree with, chances are I won't engage with that, and I won't engage with those commentators, and I'll go into my corner where people will talk to me about things that I'm interested in, but also talk to me about view or shape the world in the way that I agree with. And again, these effects of the changing media landscape, the algorithms in how we're consuming information, I think can become and is becoming quite disastrous. So what was termed the Kardashian effect, of how celebrities and the Kardashian family had started to use social media to influence consumer behaviors. I think we've now, the natural progression from that was this Rogan effect, this Joe Rogan effect or MacG effect, or whoever it is, about these influencers using podcasts and platforms to influence how we behave in civic and political discourse. And the sort of scary parts around this is that these influencers and podcasters don't follow the rules of traditional media. So they don't have to abide by the same guidelines. They don't have to fact check. They don't have to follow journalistic principles that would often exist if you are doing any type of interviews, but political interviews and so on. And they have access to global audiences, unlike traditional media platforms who don't. So this loss of trust that we're seeing in our state institutions, in democratic processes and so on, they seem to then feed into these platforms and environments where podcasters and other influencers can tap into that and then potentially feed audiences with information that is sensationalist, that is not fact-checked, that does then conform to particular worldviews. And because of a lack of regulation and control around this, there's very little accountability that these people hold. So the changing information landscape, along with the algorithms and the echo chambers that we're in, I think is also posing a significant threat to how we engage in democratic processes, because the types of information that people are consuming can no longer, we can't say that all the information that is out there is good information, because we now have good information and we now have false information. And relying on the public alone to be able to discern that, if you're not an expert in climate change, but you have a podcaster talking about how climate change is a hoax, you may then tap into some of those talking points, and that then shapes your worldview about whether or not you agree with your government's climate policies. So some of the impact that we're already starting to see is just the polarization that exists in many of our societies. There's a report by the Edelman Trust that shows that South Africa is one of the top 6 polarized societies in the world, along with the US and Argentina and a few others. And with this polarization, we've now got into corners where we're choosing to not engage with other sides, and we're potentially also we're all stuck in our very own echo chambers, which means that, if you have a particular worldview about something, this is how you perceive it to happen. And then, the reality potentially is something quite different. So my, most recent experience around this was during the elections, where if you opened my Twitter feed, everybody was voting Rise Mzansi and the ANC. And that made me think that potentially those two parties would do really well in the elections. Turns out that wasn't the case for either of them. So this type of, being pulled into different places and it is really, the polarization on issues around immigration, on climate change, on science and vaccines, around wars and genocides. We can't seem to agree on basic facts anymore, because there's these things called alternative facts, and that shouldn't even be in our lexicon. But there is a shift in the information environment, and we are now, as civil society, not only having to fight for justice and rights and try to deal with these imminent threats that we're seeing, but we're also having to start from scratch in terms of trying to convince people that this is a real issue, this impacts you. We need to we need to try and deal with this collectively. But the impacts, again, also around disinformation and in relation to democracy, is also the attacks that we're seeing on the media, and the attacks that we're seeing on journalists, and female journalists in particular. Is that it's so much, there's this chilling effect that happens where, if you're a female journalist, if you're exposing corruption or any other investigative story, chances are online there's a manosphere that exists, and they are going to attack you, and not just based on what your the content of your work, but they're going to attack you in your personal life, how you look, etc. So that is a direct harm, because we are putting journalists, on the one hand, it is important that people have a platform to voice concerns, to be able to engage, because sometimes we do know the media can get it wrong. But what we're also doing is we're inviting a lot of attacks on the media, which then also leads to further distrust against certain journalists, against certain media houses. All of this, in some instances, have been coordinated disinformation attacks. The last thing that I will say before I close off is that technology has a dual nature. So on the one hand, it can be a force for good. And I think when, for example, social media was created, it wasn't in, the Mark Zuckerbergs and so on, they weren't creating it or knowing that it would be such a polarizing force. In fact, they say that it was meant to be to connect the world. So it does have a dual nature. It can do good, and we've seen the good that it's capable of doing. But we also have to start to recognize those harms and find ways to mitigate and control those harms, because if left unattended, I think we are going to see quite significant decaying in democratic processes and further polarization in our society. So one of the things that we could potentially consider, and this is slightly controversial, because obviously freedom of expression is a valuable constitutional right that must be protected at all costs in our country. But we need to also start having that conversation around can we potentially criminalize dangerous disinformation. And I'm not talking about, silly WhatsApps from your aunties that if you don't share this message, your WhatsApp is going to shut down. I'm talking about the dangerous disinformation that leads to the, July 2021 riots, the dangerous disinformation that threatens democratic processes, that threatens public health. I think we have to there has to be some form of accountability for those who spread that, but there also has to be accountability on the big tech platforms that basically have monetized their recommendation systems, where your disinformation and your salacious content is likely to get more likes and more engagement than facts and the truth. And we need to find ways to ensure that we are carefully controlling the information ecosystem, but that we're also then not infringing on rights, which is the right to freedom of expression, and that these types of laws, if they do ever come into effect, will never then be used against activists and media houses and so on, or anybody who's presenting an opposing view. So we are on this journey. I think that we're never going to be at a point where we don't have social media and we don't have AI. And it is, I think between civil society, the government, and the tech platforms, there's this collective responsibility to try and find ways to create healthier information ecosystems, because the information ecosystems and the influence in technology can have a direct impact on democracy and the outcomes of democracy. And we have to start viewing that as, within the same ecosystem, as opposed to seeing it that technology operates separately outside of democratic norms and constitutional principles. Thanks, Thandi.
Thanks very much, Kavisha. I think you've raised some really critical points and sort of set the scene really well for shaping this discussion. And one thing that, or one area that I sort of heard come out quite a lot is this issue of accountability. So I hope we'll have time to explore some of that a little bit more once we through the presentations. But yeah, that accountability, because I think that's one of the challenges, or one of the biggest challenges that people around the globe are grappling with, the issue of accountability. And I think that also moves us really nicely into our to our next session, or our next speaker with Tina. Media Monitoring Africa we have been doing a bit of work around some of these issues around accountability and solutions, and some mechanisms that are being explored around this. So Tina, I think if we go straight into your session.
Thanks, Thandi. Good afternoon, everyone, and thank you, Kavisha, for setting the scene so well. We have a plethora of challenges before us that are complicated to deal with. But it's precisely that ubiquitous nature of the online world that you captured that makes responses quite challenging and quite nuanced. We're seeing the speed that information is conveyed, the amplification of the audiences that it's reaching, and the relative permanence with which content is staying online or living and having this longer-term digital footprint. That means the consequences of disinformation or online harms are quite compounded. And so when we are fashioning our responses to disinformation and online harms, we equally need to be quite innovative, and we need to be appropriate, and the responses need to be effective. They need to be able to reasonably respond to the types of challenges that we're dealing with. So with that in mind, I have 3 brief points to make that relate to today's topic on regulating digital spaces. And I may be taking a somewhat unpopular position, but let's see where the conversation takes us. So my 3 points relate to, firstly, a cautionary tale about overregulation. The second relates to the borderline tensions that we are seeing and how we respond to those. And then the third is a proposed rights-based approach to platform accountability and how we can maybe respond to disinformation online in a slightly different way. So let me begin with a cautionary tale. There's often a tendency to want to legislate or regulate quite quickly when there is a harm or a threat of harms. And that's a very understandable and normal tendency to have. But it might not always be the best response, particularly when we're looking at disinformation. We recently worked with MMA in engagements with the UN Special Rapporteur on the right to freedom of expression and looked at where the harms of overregulation or criminalization of disinformation may come to the fore. And we saw a concerning trend in Southern Africa, and this started or was amplified during COVID, because COVID became quite a convenient excuse for governments to say, whoa, we need to manage what people are saying because there's so much at risk right now. But what happened in countries like Zimbabwe and Zambia was disinformation regulations or laws were passed and were then used to lay charges and ultimately arrest and convict people who had spoken out against the government. And so there was this tension where it was being misused to stifle dissent or to curb any sort of expression that was targeting the government. And regrettably, this has persisted post-COVID. I was recently in Uganda and Sierra Leone, and in the last few months, there have been 2 cases in countries, one in East Africa and one in West Africa, where their cybersecurity laws have been used to lay charges against individuals who've shared content online. And in both cases, on the opposite ends of the continent, were cases that related to tweets about the president. In Uganda, it was about the president's wife, and in Sierra Leone, it was about the president. And these laws are being used to stifle dissent in a really scary way. So when we're thinking about democracy and understanding the role of the online world, we need to be quite mindful that our responses should equally not enable the stifling of dissent that has a similar consequence to how we we want to advance democracy. But this is just a caution. It's not to say that we shouldn't regulate. I do, and Kavisha, I'd love to have a further debate, think that there are some concerns around criminalization, but I do think there may be some scope for regulation or legislation, but it needs to have sufficient safeguards so that it doesn't curb any freedom of expression. This then takes me to my second point, which is the borderline tensions. And we refer to these as the tweets or the videos or the posts that may be offensive, they may be hurtful, they may be untrue, but they don't fall within the sort of the definition of hate speech or incitement or harassment or even our understandings of disinformation. So we want to respond to them, but they're bad. They're just not bad enough. And these become then quite difficult to respond to. And these might be the more benign examples of your aunt sharing a salacious video on WhatsApp. There may be the more subtle insinuations, like the use of emoticons. I've recently learned that some of the emoticons I've been using for quite some time actually mean something very different in different contexts. So I've been grappling with what a reasonable person may perceive my emoticon to mean and what the intention element is there. And then we get the more blatant types of content, the Andrew Tate-esque sort of offensive commentary where he says things like women shouldn't vote. And that's awful. I think hopefully many of us can agree that that type of content is not content that we really want to see or engage with. But that doesn't mean that we must then silence people who are saying things that we don't agree with or that we find offensive. Our jurisprudence from the Constitutional Court is very clear on this. Shocking and offensive content doesn't fall within the type of speech that should be prohibited. So we need to be very mindful that we're not overcorrecting speech, and in doing so, be very mindful of who is making the election to overcorrect. When we have certain administrations coming in powerful countries across the world, and the speech that they seem or deem appropriate may be very different from what others deem appropriate. And we need to toe that line quite carefully so that we don't overcorrect either way. And I amplify that sort of amplifies the cautionary approach to regulation, because there are these borderline tensions. And so then this takes us to where the problem actually lies. And this is what Thandi raised, and it's around accountability. Should we be looking at the individuals? Are we trying to correct people's behavior? Are we wanting ultimately people to be kinder? Is this a morals question or an ethics question? Or are we wanting to rather focus our energy on the platforms that are amplifying, monetizing, and encouraging the dissemination of this type of content and are profiting off it, essentially? And we need to figure out who we want to be going up against in this fight, because this is going to be a long fight, and it's going to be an important fight to find these balances, but we must make sure that we understand who it is that we are fighting against and why. So this takes me to my last point, and this is the proposal that I bring to the table today. And I do so on behalf of MMA. As Thandi noted, we've worked together in the past, and this is a proposal from MMA that I'll be sharing on their behalf. So essentially what MMA has come up with, which is quite a nice idea, and I think it strikes a good balance for purposes of today's discussion. And they have proposed the establishment of an online integrity ombud, or the OIO, as they've fondly begun referring to it. And they've done extensive research into the feasibility of this and have seen that an ombud or an ombud's office is a viable and valuable mechanism to respond particularly to disinformation for several reasons. And without going into the mechanics of it, which I'd be happy to do so later, I just want to paint the picture as to why this could be a useful response. So firstly, ombuds are a widely accepted form of effective and accessible dispute resolution forums. We've seen this the world over, and it's a useful mechanism. That doesn't mean we have to heavily legislate. It doesn't mean we have to run off to court every time someone does something wrong. It gives us a different mechanism and a different avenue where we can have different notions of justice and accountability. Second, South Africa has a really welcoming environment for ombuds. We have ombuds for most industries, and some of which are very powerful industries. So an ombuds office also creates a useful mechanism for individuals to engage with really powerful and financially powerful actors such as platforms or banks or insurance industries. And so it helps level the playing fields a bit so that it isn't as one-sided. Thirdly, we are of the view, or MMA is of the view, that the current mechanisms in South Africa, while really important and are dealing with content and moderation and regulation in different ways, both on and offline, are not quite fit for purpose. So we have this gap, particularly when it comes to disinformation. We have legislation relating to hate speech, incitement, harassment, and we have the forums that enable access to justice there. But on disinformation, there is a gap. So MMA is proposing that the OIO fills this gap as one of the useful multi-stakeholder and multi-pronged approaches to deal with disinformation. And finally, we, as much as this sounds like a wonderfully novel idea, it's not necessarily the first of its kind, and we're seeing other countries around the world starting to test this out. Australia is in the process of finalizing the setting up of a somewhat similar ombud. The European Union has been investigating this for the last few years and will likely trigger it. We know that our Competition Commission has been looking into considerations around this as well. So this is an approach that is being tested elsewhere because of the challenges of overregulation or of criminalization or of just finding a way to better balance the excessive power of a big platform and an individual user. So MMA has raised this innovative response, which I think provides a really useful and appropriate and effective mechanism, particularly for the question of disinformation. So without having to overregulate or overcompensate or overcorrect, we can use mechanisms like this to empower individuals while still endeavoring to find that level of accountability that Thandi was looking for. So we can go down this road as a reasonable road where we don't have to get into the weeds of criminalization. It enables us to potentially find the balance of how we deal with the borderline comms that are a challenge and what we want to do about that. But essentially, it creates a rights-based approach that enables a balanced information ecosystem that Kavisha was talking about. And it respects users' rights. And it also enables users to trust the online environment a bit more, which is why we are seeing this polarization and these tensions. So while I appreciate today's topic is regulating digital spaces, my vote is that we don't regulate, or if we do, we need to have serious safeguards in place to ensure that no harms are done to freedom of expression and democracy more broadly, but that there are viable and alternative models that we can pursue that do empower and enable a different type of information ecosystem that has a bit more integrity than the one we are currently seeing. Thanks, Thandi.
Great, thanks. Thanks very much, Tina, for that. And I'm trying to remember to keep my facilitator hat on and not my MMA hat, but I will be following up with a few questions around some of those mechanisms. I think that it would be useful if we have time to look at, just some of the practical process elements of that. And you kind of wrapped up the input, talking about the trust element, which I think is so very important to bring into this conversation. And, Maria Ressa, Nobel Peace Prize winner, and journalist, has been in the country and in various, talking engagements. One of the quotes or one of the really, I think, key things that she has said is that, and why it's relevant to this conversation is that without facts, you can't have truth, and without truth, you can't have trust. And I think that just it kind of sums up, some of the real big, challenges that we're dealing with. At the end of the day, it's about fact, truth, and trust. And I think that this also kind of lays the foundation to bring in Sherylle at this point, who, we've been kind of looking very locally at the problem and potential mechanisms for solving this. But Sherylle, if you can come in to give us a better sense of what we've seen in terms of how social media platforms have been challenged using litigation, and whether that is actually a mechanism that works, or kind of the challenges around just relying on litigation to address these issues. So Sherylle, over to you.
Thanks so much, Thandi. And very valuable inputs from Tina as well as Kavisha. And maybe when we have some little more time, I'll maybe give you my thoughts around regulating particularly social media platforms. But I want to start by saying, according to the 2023 Freedom of the Net report, South Africa boasts of having one of the highest numbers of internet users on the continent, and has often topped the charts on indexes measuring internet freedom on the continent. Global rankings are rated out of 100, and countries are rated by an examination of 3 categories: obstacles to access, limits on content, and violation of users' rights. And so the 2023 Freedom of the Net report scored South Africa a solid B, which is 73 out of 100. So we're doing pretty well in terms of balancing out the accessibility arguments, as well as not honoring or respecting freedom of speech in South Africa. But however, existing inequalities and trends concerning digital rights have emerged and should be addressed. Issues such as balancing freedom of expression against other fundamental rights, the practice and legislation on hate speech, tech platform accountability, and a potentially threatened civic space also arise, and is a direct threat to many intersectional constitutional and human rights. But my inputs today and what I've been asked to speak about will focus on tech platform accountability and how litigation can be used as a tool to influence changing harmful business practices of big tech corporations. But before I go there, I just want to touch a little bit about emerging AI technologies, because these largely fuel the business model of big tech corporations. Many people see AI tech as synonymous with progress, and while we should acknowledge the benefits of innovation, we should also be mindful of their serious social, economic, as well as political impacts, from exacerbating patterns of inequality to incentivizing content production that is harmful to young people's mental health and physical health. People's rights and freedoms offline are often jeopardized by online platforms' current business models. So where profit is being stoked by stoking up anger and fear, their business model, although opaque, monetizes maximum engagement. The ranking and virility algorithms actively amplifies divisive content, disinformation, and incitements to violence. So they are not pervasive bystanders in spreading disinformation, including in such things as election disinformation, and worryingly, it amplifies hate speech and calls for violence. So I think this is a very particular issue that we must pay attention to. And all of the cases that I'm about to tell you about really is targeting these harmful business practices. And we'll talk a little bit about particular cases that have emerged around this. But there are a range of rights that are impacted by this business model. The right to privacy. AI models are generally rely on enormous data sets to function. So big data surveillance systems aggregate and analyze massive amounts of personal data, gathering people's most sensitive information. The second is access to information. Platform algorithms have promoted incendiary content over reliable information. I think Kavisha talked about that point. And then lastly, equality and non-discrimination. It has been seen, and there's been various investigations and research done on how algorithmic systems can perpetuate violence built into their training data, and these exacerbate long-standing discrimination. So how do we hold big tech accountable for online harms that can translate to real-world harms? South African jurisprudence on this issue is very scant, and we are yet to test the appetite of our courts to hear and adjudicate a case that directly speaks to these harmful business practices. So much of the litigation has come from the United States and Europe, where big tech corporations are headquartered and where there is an existing regulatory framework in place that creates accountability mechanisms, that creates legislative obligations on big tech corporations to ensure the protection of personal data. And it also calls for more transparency on their business models. And finally, it gives recourse for online harms. In the US, for example, so one of the key legal shields enjoyed by big tech corporations is Section 230 of the Communications Decency Act. Section 230 was adopted in 1996 and became what is known as a core pillar of internet freedom, and is known as the law that gave us the modern internet. But this law was introduced following a US court ruling in 1994, which essentially reversed the position that was there, prior to 1996. In this case, Stratton Oakmont was sued an online service prodigy due to an accusation that someone had posted on Prodigy's finance-themed bulletin board about Stratton Oakmont. So Prodigy argued that it was a platform and not a publisher, so they couldn't be held responsible for their users' posts. But the court in that case found that since Prodigy moderated posts, for example, editing for foul language, they could be held liable for what users posted on the site. So a US senator who spearheaded the introduction of Section 230 believed that this court ruling was wrong. And therefore, Section 230 was introduced into law. And Section 230 created a blanket legal immunity for websites. So online platforms can't be held legally liable for something posted by another user, for a third-party user. And even if those platforms moderated posts or set specific standards. And this legal immunity, some people will say, represents power without responsibilities. So litigators in the US had to become very creative in how they circumvented Section 230 immunity. And there were many cases brought before the courts that challenged the toxic design of the platform. So the first case that I want to tell you about is Lemon versus Snap. So in this case, the parents of two boys sued Snap after their sons were killed in a high-speed car crash. They alleged that the speed filter that was used in the defendant's application, which is Snapchat, played a role in the accident. Snapchat had a filter that recorded users' real-time speed, and many users suspected or believed that Snapchat would reward them for recording 100 miles per hour or faster snap. And here the plaintiff argued that Snapchat allegedly knew or should have known that such a reward system would incentivize young drivers to drive at excessively high or dangerous speeds. They also argue that Snap had negligently created the product, which is Snapchat, and it sought to hold the company liable for its role in violating their duty to design a reasonably safe product. So this case was really brought in on a product liability angle. And plaintiffs alleged three things. Firstly, that Snap created Snapchat, which is the platform. Secondly, they created the speed filter. And third, they created an incentive system which encourages users to perform certain unknown achievements or rewards. They argue that the speed filter on Snapchat was defective, irrespective of the content being posted or published, because the speed filter and the incentive system supposedly worked in tandem to entice young users to drive at excessive speeds. They also stated that the defendant could have met their duty to create a safe product by no longer providing this filter, and not just by changing how or who published any third-party content. The Ninth Circuit Court identified this case as a clear example of a claim that simply did not rest with just third-party content. So to determine if the parents have stated a claim under negligent design, they had to show that it's probable that the manufacturers breach their duty to exercise due care in supplying products that do not present an unreasonable risk of injury or harm to the public. So negligent design actions asks if a reasonable person could conclude that the reasonable foreseeable harm of a product manufactured in accordance with its designs outweighs the utility of the product. The courts had to determine whether Section 230 applied. And in order to do that, they applied a three-pronged test, which was set out in a previous case of Barnes versus Yahoo. So Snap would enjoy immunity only if they could show that they were a provider or a user of an interactive computer service. Secondly, whom the plaintiff seeks to treat under state law cause of action as a publisher or a speaker. And then third, of information provided by another information content provider. So in this case, the court decided that Snap is a provider of an interactive computer service, so it met the first prong of the Barnes test. The second was the plaintiffs did not seek to treat Snap as a publisher or a speaker, since their claim was based on Snap's flawed design of Snapchat filter. And so Snap failed the second prong of the Barnes test. And then the third, Snap failed also the third test, because the negligent design claim does not turn on the information provided by a third-party information content provider. So Snap could not get immunity under Section 230 in those instances. So in this case, the judge reversed the initial district court's dismissal of the plaintiff's complaint on the grounds of the Section 230 amendment and allowed the plaintiff's negligent design lawsuit to proceed. The second case that I want to discuss, or the second strategy that was highly successful to overcome Section 230.
Sorry, Sherylle, your connection seems to be a bit problematic. We lost the last 10 seconds there. I'm just trying to see if we've lost you altogether or if we can, Sherylle. No, I'll give her a few moments to try and reconnect. And what a point to for tech to hinder us. What a fascinating examples from Sherylle. But while we wait for Sherylle to rejoin, please remember to post any comments or questions. We do see the comments and questions coming up. There will be an opportunity for the panel to engage with questions once we've gone through the formal input. But you're welcome to post any comments or questions as you think of them. They do stay on the question board, so please feel free to do that. I'm going to, just before I get into maybe some questions for Kavisha and Tina, I just want to check in with Chris to see if you have heard from Sherylle, if she's able to reconnect.
Hi, Thandi. No, I haven't. Let me. I'll send her an email, and then we can try to get her back on.
Okay, perfect.
We can always we can switch to the Q&A that we had for Kavisha and Tina, and then we can find a way to get Sherylle back on.
Yeah. Okay. Great. Thank you. All right. So I think maybe we can take the time, take this point to go back to some basics. We were really in depth in kind of a litigation mindset, But I want to bring us back from that just for a moment, and I want to chat to you or ask you, Kavisha, your thoughts on maybe, sharing with the audience what makes disinformation go so viral so quickly. I think we often forget, that users are part of disinformation spreading, and really play such a critical role in distributing that disinformation. We often very focused on platforms and accountability, and very rightly so. But maybe let's go back to that sort of critical thinking space of what actually makes disinformation go so viral and pose such a problem.
I mean, I think there's definitely a psychology to disinformation. And it's it picks up on traditional, I guess, information consumption patterns. So, for example, prior to social media, I think they still do pretty well, is tabloid newspapers that have all of the gossip and all of the juicy bits and all of the tea of the celebrity and so on. So there's something in the psyche that likes the gossipy parts of information more than the boring things that we have to, that we sometimes have to talk about. So if we take, for example, our webinar today, you put our webinar versus some Joe Rogan or MacG or anybody else, chances are people are going to tune there because there's potentially something that's going to pique their interests. So there's definitely a psychology around this, but I think what we're seeing in terms of viral disinformation, where the dangerous stuff is usually appealing to people's fears and biases in some way or form. And that then results in an action of some sort. So if you are speaking about immigration, where South Africa has had a terrible history of xenophobia, and in 2008 and onwards, where there were these sporadic incidents which you were then able to quell and be able to respond to. What we're seeing in online spaces is xenophobic commentary has become so normalized, that it just seems like it's part of as part of our discourse at the moment. So there's, what would, somebody creating content around this would appeal to biases around, well, foreign nationals, maybe they fit some type of tropes around criminality, so you're not safe. And we know that we have high crime levels in the country. We also have high unemployment levels, so they're taking all of your jobs. And all of a sudden you have groups of people who believe that the problems that we're facing in South Africa in relation to crime and in relation to unemployment is solely it's the fault of foreign nationals and nobody else. So, it plays into some of our most basic fears and identities, and that then gets max amplified because the more people, if I start to believe this and then I go online and I see a few other people are starting to agree with me, it's like, well, okay, actually, maybe this is true, so there's a lot of confirmation bias that's happening in relation to these echo chambers that we're in. If I agree, if vaccines work or don't work, I will go and source that material that will confirm my preconceived notions, ideas, or biases around this. And I think one of the ways that we have to deal with this issue is digital literacy, meaningful digital literacy. I think literacy is important, media literacy is important, but then there's also this aspect of digital literacy is understanding why you're receiving this information, where is it coming from, are you potentially being targeted here, how do you go and fact check, how do you go and see, if this comes from a credible source and so on. So that I think digital literacy along with media literacy is vital in terms of helping ordinary people on social media platforms potentially build develop some capability and capacity to resist the spreading of disinformation and avoid it from going viral.
Fantastic, thank you. I think that was really, really great to again just kind of delve into some of the I mean, for lack of a better word, the nitty-gritty elements of disinformation and why it's such a human-centered phenomenon. Sherylle, welcome back. Very glad that you were able to connect. Hope it holds out, because what a fascinating input. So please carry on.
I'm not sure where I got cut off. At what point, or did everybody not hear anything that I said?
No. So we got most of it. You had just wrapped up the case about the Snapchat, and you were moving into your second, into the next.
I see. Okay, so the second case was really a challenge on algorithmic bias, and it was a very interesting case because it looked at the discrimination angle to try and circumvent this legal immunity that Section 230 provided under US legislation. So in this case, Samantha Lepers versus Facebook. Here, the Lepers was a 48-year-old woman. She was a regular Facebook user. And she wanted to explore insurance products through ads on her newsfeed because she wanted to purchase life insurance. Well, however, she couldn't access certain life insurance ads because of age and gender restrictions. And these restrictions prevented her from seeing relevant ads and which were targeted specifically to a specific age group and gender groups. So consequently, she missed out on opportunities to qualify for insurance, obtain quotes, or learn about insurance-related products. So in 2020, she filed a class action against Facebook, claiming that the platform violated the Civil Rights Act by engaging in age and gender discrimination. She argued that she and other class members suffered from harm by being treated unequally based on their age and/or gender. She failed in the first quarter in the trial court, where the court again said that she didn't show evidence of intentional discrimination because Facebook's default settings, audience selection tools, and lookalike audience were age and gender neutral. The court, however, and further rejected an argument that the algorithm intentionally discriminated to boost engagement and revenue. Facebook argued that she did not have legal standing to pursue a claim under the Civil Rights Act because she did not suffer any harm from ad targeting techniques. They also argued that their tool was neutral and not discriminatory. Ultimately, the appeals court came to the conclusion that she actually did present enough evidence to support a cause of action, and the judgment was overturned and she was granted rights to receive her costs on appeal. During the period 2016 and 2018, there was a slew of cases filed against Meta on similar bases, alleging that Facebook's advertising platform enabled discrimination in housing, employment, and credit advertising. So these cases specifically targeted housing, employment, and credit advertisers that were included or excluded Facebook users from receiving their ads based on protected grounds. What were the outcomes of the case, or the consequence of that litigation, was that Facebook agreed to make changes to its ad platform to prevent advertisers in these areas from discriminating on the basis of race or national origin, ethnicity, etc. The last case that I actually wanted to speak to you was around a wrongful death suit that was brought in the United States against TikTok. This was a case brought by a family of a 10-year-old girl who unintentionally hung herself following a content that she saw on her For You page. So in this case, the case alleges that TikTok, via its algorithm, recommended and promoted videos posted by third parties to a 10-year-old girl, Nyla Anderson, in her uniquely curated For You page. On the one video depicted the blackout challenge, which encourages viewers to record themselves engaging in acts of self-asphyxiation. After watching the video, Nyla attempted the conduct displayed in the challenge, and she unintentionally hung herself. Nyla's mother then sued TikTok and ByteDance, its parent company, for violations of state law. The initial court dismissed the complaint, holding that Section 230 of the Communications Decency Act immunizes TikTok, and Mrs. Addison then appealed to the federal court. The federal court relied on a previous decision of the Supreme Court regarding in Mooney versus NetChoice, and this was regarding whether or not platforms like TikTok and Meta or social media platforms control whether or not platforms control how others see posts posted by third parties, and whether that constitute their own essential speech or direct speech. The court held that the platform's algorithm reflects editorial judgments about compiling third-party speech it wants or in the way that it wants. And this is regarded as the platform's own expressive product and is therefore protected as free speech under the First Amendment. The court held that given the Supreme Court's observations that platforms engage in protected first-party speech under the First Amendment, when they curate compilations of other people's content via their algorithms, it does come in the purview of Section 230 on the basis that they are promoting speech themselves. And in this case, Facebook's For You page algorithm decides on the third-party speech that will be included or excluded in the compilation, and then organizes and presents them in a user's For You page. The court found that TikTok's algorithm recommended the blackout challenge to Nyla on her For You page, and this was TikTok's own expressive activity, and thus is considered first-party speech, and therefore Section 230 immunity does not apply to TikTok. So I thought that was a very, very interesting case. I think the last point that I want to raise is around one of the biggest challenges I think that we will experience outside of global North countries and European countries is the issue of jurisdiction. I think one of the currently two successful cases that come before the Kenyan courts, where Meta had challenged these cases that were brought in the Kenyan courts on the basis that they have of jurisdiction, and the Kenyan courts have said that they do have jurisdiction because Meta's business essentially had taken place in Kenya. So I think that was an important case for us to look at in the future when bringing litigation in South Africa or within the region itself. So I think I'm going to leave it there, Thandi. Thank you so much. And sorry for the interruption.
No problem. Thanks so much, Sherylle. And your connection seems to be quite stable for now. So we got all of that. So yeah, really, really fascinating examples. And I think I want to come back to some of the points that you made, but I just wanted to follow that with asking your thoughts on, the cases that you used as examples, or let me rather say, access to legal support and access to going down a route of litigation is quite prohibitive, and so I guess your thoughts on, they're a very select few people who would have the financial means as well as the sort of knowledge about the options of even being able to challenge social media platforms. So maybe just your thoughts about that and access to litigation, but as a follow on from that, you know, if litigation is does pose a challenge, or if there are challenges, I'm very glad that you raised the issue around jurisdiction, because that is one that comes up a lot, and not only in terms of individual litigation against platforms, but also, you know, holding platforms accountable broadly. I think the issue of jurisdiction is still very problematic. And you also mentioned, you said right at the start that if you had some time, you would comment on, you know, some of the proposed thoughts around regulation. So if you could just expand a little bit on those points. I think we do have some time. We don't have questions. I'm going to address the one question that we do have. But yeah, if you could address some of those thoughts, and then Tina, I'm going to come to you after that.
Yeah, I think let me start by giving my thoughts on regulations. I think one of the most important issues, and I do take the point that, you know, Tina raised around being cautious about over-regulation. But I think in the absence of any type of regulation, we are going to have those issues around being able or using litigation as a recourse to online harms or to holding tech platforms accountable. You know, the Digital Services Act and the Digital Markets Act in Europe has been hailed as one of and it's a good example of how regulation can be balanced and can balance competing rights around, you know, the autonomy or promoting innovation at the same time, but also mitigating against tech platform harms. And so it's also about, you know, balancing the rights to privacy. So the DSA, the DMA, read with the GDPR, are all pieces of legislation that speaks to that. Obviously, that legislation can never be replicated in Africa and can never be replicated domestically because we live in different contexts. But it's a useful source of information or content that we can draw from, lessons that we can learn. Obviously, the DSA and the DMA are still, you know, it's going to be gradually implemented, but we've already seen successes around the EU holding, you know, Facebook or Meta accountable for huge data breaches. And so I think it's a good mechanism for us to have. In the absence of having that, the only recourse that we have is through litigation. And we will encounter challenges around litigation, particularly the jurisdictional issues. The saving grace for South Africa is that we have such a good foundational document in the Constitution. Even with regard to the way we interpret our hate speech laws. I mean, there's lots of jurisprudence around how hate speech has been interpreted. Our Constitution specifically gives us a roadmap on how hate speech should be interpreted, for example. It is not an absolute right as the way Americans perceive their First Amendment rights of free speech. But it's unfettered, that you can say what you want, and this is where that blanket Section 230 immunity came from. It's around that. It's going in another direction. And with our hate speech laws, the inclusion of the limitation on hate speech, because it's not there, is a limitation, right? It's limited to the extent that it does not promote war, incitements, or even imminent violence, or advocates hate on protected grounds. Now, that limitation was thoughtfully and intentionally put in by the drafters of the Constitution to protect at-risk groups. And it should be understood against the historical atrocities of the dehumanizing narratives that the apartheid government committed or propagated against Black and brown people in South Africa. So this limitation sought to eradicate the use of dehumanizing, hateful narratives. And our courts have actually pronounced on this. I mean, in hate speech cases that we've already heard of around, kill the Boer slogan, singing struggle songs that may be offensive to Afrikaners. And the courts have balanced those views out. And so I think that we have that very good foundation around how we could possibly regulate big tech. With regard to litigation being prohibitive, and I do like the idea of an online integrity ombudsman, but my view is that it should complement regulation. People have recourse to the equality courts around hatred and discrimination. But the thing about online speech and the virility and the reach of online speech that is harmful and which amounts to hate speech or incitements to violence is that you can't, once it's there, it's there. You can't, no matter how you litigate, no matter how you do, you enter into dispute resolution forums, it's hard to regain your dignity once your reputation is being tarnished. It's even more so for at-risk groups like migrants, like women, like LGBTI community, like refugees. It's hard for you to undo the damage that has been done on a platform. It can give you recourse to damages, but really money does not. For me, it's my opinion, money does not give you back your dignity. It doesn't take back the years of trauma experienced by online hate. So for me, I think it should complement each other. And the last thing that I would say on that is, when it comes to litigating against big tech, it's really about using litigation as a tool for them to change their behavior. The only way that hurts tech platforms that monopolize the space, because they have a monopoly over this, is to litigate on product liability at a very high level. So while individuals may have issues litigating individually on tech harms, we as civil society need to look at the bigger cases, the case that would fundamentally change the way the business operates. And the way that we want the business to operate is we want it to operate within a rights-based framework. And at the moment, there is no incentive for them to do that. The only incentive, or the only way for them to get to that point, is to have some sort of regulation. And secondly, is to complement that with litigation. I hope, Thandi, that sort of answers your questions.
Absolutely. Thank you. And I think, raising the online integrity complementary with regulation. And I want to bring you in, and get your thoughts on that, but also take a couple of minutes, if possible, in quite briefly, in just expanding a little bit more about the practicalities of the ombud, things like where would the office sit, and how much kind of authority do you foresee an ombud having over platforms in terms of accountability? So, but yeah, based on Sherylle's thoughts about this complementary regulation elements, if you can elaborate on that.
Thanks, Thandi. Thanks, Sherylle. So maybe before I delve into that, I just want to clarify the vote that I gave at the end of my remarks, saying I don't vote for regulation. I don't vote for the regulation of content. I'm nervous about what happens if we regulate disinformation and individual users. I'm very open to regulating big tech, and I think we quite clearly need to do that. And so what MMA has done, they have a two-pronged strategy. So the first component is the Office of the Online Integrity Ombudsman. And they've proposed this as the point of departure because we know how long law reform processes take in South Africa. If we look what's happening with copyright at the moment, we see that there are serious challenges in how long it can take us to fix a law or to get a law off the ground. So MMA wants to start off with the OIO because it's easier to set up an ombudsman. We're sort of looking at a 2 to 3 year process versus a potentially 10-year law reform process. So starting that off as an initial mechanism, but then most certainly coupling it with a tech platform accountability framework. And this will require possibly amendments to the existing frameworks that we have, which is why it becomes a bit more complicated. So the initial thinking of MMA was to come up with a DSA for Africa, essentially. But once they started delving into that, they saw that this will take a little bit of time to get right, but wanted to figure out something in the interim that would then complement that. So I just wanted to clarify that. So fully on board with the OIO being supported with a regulatory or legal response. Then in terms of how the OIO actually works, and this may address some of the tensions that have arisen. So I'll start off with the overarching sort of functions of the OIO, then the model that it follows, and then just quite practically how it would work. So the three purposes that MMA sees the OIO fulfilling at this stage is, one, to be a complaints mechanism for individual users to lodge complaints about platforms who failed to respond to severe or individualized sort of bouts of disinformation. So it's an opportunity for an individual to say, I've lodged a complaint with social media platform Y, and they have not responded. This content is sharing, and these are the consequences of it. I've received no response from them. Something needs to be done. So it enables a pseudo appeals mechanism for individuals to complain about it. It then also enables an independent party to assess the conduct of platform Y. Have they got appropriate community standards? Have they just simply ignored user complaints? What steps have they taken to appropriately address disinformation? Are they labeling content appropriately? When content is clearly being used in a sort of profit-making scheme, have users been notified of that? So there's this complaint mechanism process, which I'm happy to elaborate on as well. The second is then the accountability component. So it's complaints, accountability, and then digital literacy. So the accountability component leads into the model. And here MMA is proposing an incentives and disincentives-based model. So the incentives-based model is to say, and this happens in many ombuds sort of structures in South Africa, and I appreciate there may be some pushback on this because we are reaching for the stars here somewhat. But the incentive model is to say, look, we know you're powerful. We know you care about money, but we want to try make the world a little bit better. So we're offering this model where if you can prove over the course of a year or 2 years that you've taken reasonable steps to try better respond to disinformation online, you may be offered a tax incentive or a tax rebate in South Africa. You may be offered some sort of certification which enables your operations in our country to be easier. So we're incentivizing good behavior. But we know that this may not be sufficient, given that, to speak frankly, we are South Africa and we're playing with some really big fish in the international arena who may simply just say, we don't care. So then we need to have a disincentives model to say, you may not want to act positively and you may not want to correct your behavior to be better. So if you don't, and if we find that there are these consistent patterns of you enabling and profiting off disinformation, we will fine you. And that then becomes the incentive-disincentive model. How that will actually work requires us to flesh out what type of membership model we would have. And this then depends on where it's housed. So this is all relatively a nascent idea from MMA, and we've been floating it with different stakeholders to see what interests are and where this may sit. One of the proposals is that it goes to the Human Rights Commission, and they have a separate body within the Human Rights Commission who manages that. And I think there's a lot of value in it, particularly given all of the rights-based elements we've discussed today. There's a clear Human Rights Commission mandate overlap that would be useful. If it sits independently from the Human Rights Commission, we would need to set up a membership model. And here the proposal is to follow the Australian example, where there's either a pilot phase where membership is mandatory. So if you want your platform to be used in South Africa, you are automatically a member of the OIO for a pilot period while it gets tested. Alternatively, you sign up or don't sign up. If you elect not to sign up, then you may not be allowed to operate. This is, again, something that Australia is testing out. So we're just watching to see how that unfolds and what that means. We have seen Australia take pretty seismic stances in response to how platforms are operating in their jurisdiction. So we just want to monitor what that looks like before we fully delve into that. But the membership model will depend on where it sits. And this then takes us to jurisdiction, which is obviously a tough nut to crack. We all accept that. But we've drawn on, and Sherylle, I'm glad you mentioned it, we've drawn on the DSA and we've drawn on the UK Online Safety Act, which is not without its problems. But in terms of jurisdiction, it has been really useful in how it's found creative ways to found jurisdiction. So we want to found jurisdiction for the OIO against tech platforms by saying, if you have users who are in our jurisdiction, and if there's a sufficient number of users who form part of that, and the content relates to users or has an impact on users. So we tie it in that way. And because we're not doing this through litigious processes, we have a bit more leeway with jurisdiction. So we're pulling on the different threads of the jurisdictional basis of the European and the UK legislation to found a looser model of jurisdiction for the ombud. And that's essentially what we're envisaging at this stage. So similarly to how if you put in an insurance claim and your insurer elects not to pay out, you can then go to the short-term insurance ombud and follow all of those steps. We would see it as a similar process and provide different incentives to enable the platforms to proactively participate and try be better, as well as disincentives for when they are genuinely polluting the online ecosystem in a horrendous way that they need to be held accountable. Thandi, I'm not sure if I've gone into too much detail or too little detail. I'll defer to you if you need me to elaborate on anything.
I think you've opened up for a second panel discussion. However, we do not have time to continue for another hour, which I would love to do. But no, thank you very much, Tina. And Kavisha, before I come back to you, Tina, there's a quick question about on the chat from Ezekiel. Can users also report media houses who publish mis and disinformation to the ombud, or is it just for the platforms?
Great question. I can answer it quite quickly. So short answer, at this stage, no, that's not the intention. We already have the Press Council who should be responsible for that. The Press Council's, their current wording on social media is a little bit iffy, and they may want to think about updating that. But the focus is on the platforms, not about sort of publishers. We already have those existing mechanisms, and we don't want to create any overlap. So for now, the intention is for an individual user to report against the tech platform rather than against a media house who publishes disinformation. If I'm understanding the question, can users report media houses? Yes.
I think that addresses it.
The press council is the appropriate mechanism for that, and we wouldn't want to blur that line. If the platform is enabling the media house to consistently report, you could still go to the ombud, but again, you're going after the platform who's enabled the media house rather than the media house as the primary target.
Thanks, Tina. Kavisha, we've got a couple minutes left, and I'm going to ask you to do something somewhat challenging. But you mentioned, or you briefly spoke about the need for media and digital literacy in sort of a different approach, instead of, alongside focusing on platform accountability and regulation, we also need to bring in that element of digital literacy. I wanted to ask if you had any thoughts on how that, on sort of solutions or models of digital literacy, But in the same thought, one of a question that came through quite early on in the discussion, but I think it poses an additional question, was about disinformation relating to individuals. And yes, this particular discussion was around online platforms, regulation, not necessarily looking at engagements on a one-to-one basis. But I thought it provided a kind of good point for us to sort of look at the concept of disinformation between individuals or sort of at the collective. So just some thoughts and maybe a closing remark from you, and then Tina, Sherylle, I'll come give you just 30 seconds as well to wrap this up. But Kavisha.
Thanks, Thandi. I think with I've worked in the anti-corruption space for over a decade, and to borrow some terminology, they talk about how fighting corruption is an all-of-society approach that requires every single person to put their hat into the ring to try and eradicate this problem. And I think dealing with false information and improving the integrity of our information space is also an all-of-society approach. So it requires us as users and consumers to play our part into act responsibly in terms of how we receive and spread and create information. There's a requirement on civil society, the media, the government, tech platforms. There is a role for every single person. And I think going about defining those roles and ensuring that people are actively contributing in a positive way is part of the struggle of getting governments to see that this is an issue, getting tech platforms, bringing tech platforms to heel, to be honest. And just to sort of touch on the big debate between the three of us around regulation and so on, and I really wish we can have another one where we can debate this, is that it is that fine balance. It's that fine balance of freedom of speech, but also there are limitations where people are creating and disseminating dangerous disinformation that has broad public impact. We have to find some accountability mechanisms for that. Tech platforms and what they bring to our societies and understanding how they can strengthen our democracy and enable it is important, and we support that. But making sure that they're compliant and they're working within a constitutional and human rights framework is necessary. So, we have to, there is a balance, but I also think that we've also given too much of leeway, which is why we are in the situation that we're in. And working towards addressing that is going to be really important. In terms of the question that came through around disinformation on a personal level, it's quite a tricky one because obviously people lie to each other every single day. So that becomes hard to you. I don't know if you can regulate that. I don't think you can. So when we're talking about false information, disinformation, if we are going to try and legislate around that, we are going to need to have quite tight definitions around this about what do we mean when we say disinformation, what do we mean when we're talking about misinformation, who is ultimately responsible? Because somebody who's spreading lies thinking that they're the truth should never be held accountable. Somebody who's intentionally creating dangerous information in order to cause societal harm, there should be some accountability there. That's what I believe. So yeah, just in terms of wrapping up, there's a lot of debate to be had around different models. I think that we're very early we're at the start of this journey of trying to think about guardrails and accountability, but those conversations are absolutely necessary. And when we're going into further elections and so on, we know and we can now anticipate that the amount of, the types of disinformation that we saw in the 2024 election come local government and further on, these are just going to get heightened. So how do we try and protect our democracy? How do we try and do the digital literacy trainings? And sorry, Thandi, just to answer your initial question there, the digital literacy trainings, I think, is something that's so important where similar to how we do voter education, how we do media literacy. It should be, everybody should try and get online, try and learn about how the algorithms work. Go to institutes like Code and Africa Check and others who offer these types of training. And then the government should also be brought into the picture of how they can roll out mass digital literacy trainings, because it's a really important skill given the time that we're in.
Fantastic. Thank you so much. And I think some brilliant points to sort of round us off in that. And you're right. I mean, debating these issues, it would be great to have half a day to do it. So we've just hit 2:30. So Tina, Sherylle, if you can just sum up, just give us a closing thought to wrap up your points in 30 seconds. Tina, and then Sherylle, I'll come to you.
Thanks, Thandi. And to just briefly say that a lot of this does sound scary because we are going against big platforms. But just a reminder that we didn't used to have seatbelts in cars, and we used to smoke on airplanes, and mining houses never used to be held accountable. Accountability sometimes takes time, particularly against powerful actors, but it is most certainly achievable. We just need to get it done. Thank you, Thandi. And thank you, HSF, for hosting such a fantastic conversation.
Fantastic. Thank you, Tina. And Sherylle, you've got the last word.
I think that Tina summed it up very well. I mean, we've always, if we are sold a defective car, we have recourse to challenge it. This is a defective product. It's designed to spread hate. It's designed to keep people addicted to the platform, particularly young children. We need to challenge that. And I think the cases that I've highlighted gives us some type of roadmap of how we can do that. And we just need to get it done. And again, thank you for having me. It was a really lovely conversation.
Fantastic. Thank you so much. Thank you to all three of you panelists. I wish we could keep on talking about these issues, but really critical points. And I think just laying foundations for further engagements, further discussions, and hopefully some practical, real life solutions to these problems in the very near future. So with that, Chris, back over to you. And sorry, we are 2 minutes over time.
So can you unmute me? There we go. Thanks. I think that's a really great way to end. After an hour and a half, I did get the sense that we were just getting started. So I think that's a really good sign. And it was really good to hear that our whole panel and our facilitator enjoyed the discussion as well. And just thank you so much from HSF's side for taking the time out of your day to treat us and our audience with such an enriching discussion that I'm sure will circulate widely and give us food for thought for a long time to come. So thank you very much, everyone, and have a great day.